international dispute settlement mechanisms. It is my pleasure to introduce our distinguished speakers. We'll begin with Professor Teresa CHENG, who is a senior counsel at International Arbitrator. She's currently Adjunct at Tsinghua Law School, co-director of the Arbitration and Dispute Resolution Law School, and co-chairman and one of the founding members of the Asian Academy of International Law. And by the way, Professor Chen was also recently the Secretary General of International Organization for Mediation. During her career as a lawyer, and she had the resolution of a wide range of commercial and investment disputes. Woman to be elected President of Chartered Institute of Today, Professor Chen will present on the topic of organization for key to peaceful settlement of disputes. Next, we will hear from Professor Volker Roeben, the Dean of Durham Law School. Professor Roeben and editor of 8 books and over 50 articles. His research is in the international law, a focus on the law and policy of energy as well as he frequently advises government and international organizations. His presentation today is titled Development in the Practice of Energy Disputes. Following him, we have Dean of University of Malaya, Professor Chuah, is the leading authority in commercial and maritime law with prolific research portfolio in international shipping and insolvency law of emerging knowledge such as AI. In this session, he will share his insight on TRC. Our last speaker is Professor Lisa Toohey from the Faculty of Law at the University of New South Wales. Her research is focused on the question of how individuals and groups understand and interpret their rights in order to resolve disputes at international, domestic, and transactional levels. This includes a focus on how states in the Asia-Pacific region engage with the international trade system and resolve disputes, how mediation can be better used to address multi-issue public international law disputes, how individuals in civil disputes assess and interpret legal information, and how legal design can be used as a tool to better facilitate understanding of legal information. Today, the promise of mediation in international trade disputes. And finally, we will have Professor Xinjun. Glad to see you commentator. Thank you very much. So let's start with Professor, please.
Thank you very much, Professor Zhang, for that very kind introduction, and very nice to see all of you here. I have to start by saying I am playing this on home ground, because this room, 509, is the standard classroom for our classes of the International Arbitration and Dispute Settlement course. So I feel very much at home, first of all by reason of the classroom, but also by reason of being back here in Tsinghua for this particular talk. Happy birthday to Tsinghua again, 30 years, and having achieved so much in the past 30 years really is remarkable. And I think the teachers and the students here are really making everything work. So it's a great community to be at. Now, the talk that I'm going to give you is to look at the International Organization for Mediation in the context of its role in peaceful settlement of disputes. Now, Tsinghua is 30 years old. For a law school, it's comparatively young, and I think almost very young. And of course, by reason of the achievements, you would have thought that there is a lot more standards and a lot more experience it has had. But compared to International Organization for Mediation, we are just 1 month and 2 days old. We opened for business, as it were, on the 20th of October, and this has just been a month away. In Chinese, we have a 满月, so we've just been 1 month old, and we had our little celebration actually when we were in Chongqing 2 days ago. So for this very new organization, and to look at our role, what I'm going to do is to tell you how it was set up, why it was set up, and I would then ask the question, what now? So how was it set up? The discussions amongst whether or not to set up a mediation was initiated some time ago, first by China, but also by a number of countries around the world, 18 of them to be exact, and they had a number of informal consultations and meetings, and then in 2022 they made a joint declaration, a joint statement, declaring that they shall look into the establishment of an organization that is dedicated for mediation. So the idea of it came from that joint statement. Thereafter, a preparatory office was then set up. The preparatory office opened in February of 2023, and that was established in Hong Kong SAR, and they hosted a small number of people, but very efficient people working at the preparatory office. The preparatory office was then responsible to coordinate the negotiation of a convention, which is called the Convention on the Establishment of the International Organization for Mediation. The convention itself was negotiated just under 2 years, and it was concluded round about October or towards the end, let's say, of 2024. Then a number of things have to happen, states having to take into consideration whether or not to sign, etc. And so, on the 30th of May this year, there was a signing ceremony held in Hong Kong SAR for the signing of this convention. And China's foreign minister, Wang Yi, was there, and a number of other representatives from various countries were there. I believe from over 60 or 80 countries from around the world. The convention was signed on that day by 33 states. Now we have 38 signatory states, but on that day alone, 33 states. And then on the 29th of August, the convention came into effect. 3 states have by then rectified, and therefore the convention is in effect. Then, in less than 5 months from the signing of the convention, that is on the 20th of October, the first Governing Council meeting was held, And the first Governing Council meeting appointed myself as the Secretary General, and then declared that and then adopted a number of rules and declared the establishment and the open of operation of the IOMed, the International Organization for Mediation. So that is how, as I said, it was set up. Now then let's look at the why. Why did these countries feel the need to establish an international organization for mediation? I start with the United Nations Charter. Article 33 of the UN Charter provides that for peaceful settlement of disputes, mediation is one of the ways that can be done, and in fact it's one of the first two or third item on the list that are listed in Article 33 of the UN Charter. And so mediation was very much in the minds of everybody, all the states, when they were signing up the Charter and when the Charter was established. Yet, for whatever reasons, the Charter provided for litigation and arbitration as well, and as we all know, very established and very excellent services have been provided to the international community is the International Court of Justice and of course the Permanent Court of Arbitration. They were both established by treaty. There is of course, you will all know that in the context of investment disputes, the ICSID, the International Center for Settlement of Investment Disputes, also established by the Washington Convention in 1965, not at the time of the UN Charter, some years afterwards. So these bodies were established, but they were established generally with a view for litigation and arbitration. Up until now, there wasn't any body that was set up, established by treaty, that is amongst a number of states, that establish a body that is dedicating exclusively to using mediation to resolve international disputes. So that is why the establishment of the IOMed is a very important breakthrough to provide the international community with a choice, if they wish to use mediation. And therefore, I tend to use the phrase that it fills an institutional gap. So we have the ICJ, we have the PCA ICSID, very established, and of course we now also have IOMed that provides for mediation in the context of international disputes. So that is one very important matter to bear in mind. The other thing that people would also be thinking of is, well, is this mediation body that is set up going to replace ICJ or PCA? I emphatically tell you, no. It complements and never intends to replace, because these are very important bodies and very long history serving the international community in a different way than mediation, but nonetheless a very important way. So therefore, the second element of IOMed is that it complements the current system of litigation and arbitration that is available in the international community. So it fills an institutional gap, but also complements the current services, the current international bodies, giving the parties a choice to decide what to do. The third reason is a more practical reason. Now I want you all to look at the matter from the perspective of the parties, and then compare arbitration litigation with why mediation. All of you would know, one of the greatest benefit of arbitration is that it's final, it's binding, it's enforceable. That's brilliant. With litigation, the only one added, perhaps not as advantageous, but still in domestic court, that is the question of appeal. Of course, in ICJ, we do not have that situation. So, final, binding, and enforceability. Now, when you look at mediation, these are not necessarily a true advantage. If we understand the context of mediation, mediation is voluntary, parties trying to agree to settle the dispute, not deciding who is right and who is wrong, but to find a common way forward so that the dispute can be resolved, but they keep the relationship whilst moving forward. So with that in mind, whether something is final in the context of mediation may not be that good. The mediated settlement may want something that is evolving, that is continuously working, and not sort of final as if it draws and put a full stop to the relationship. The fact that it is binding is of course applicable in all three types of mechanisms, but in the context of mediation, it has the benefit of being binding on a voluntary basis. And I mean true voluntary basis. Because in arbitration and litigation, sometimes you contest that, you know, as a party you may say there is no jurisdiction or that I should have won. And yet the third party neutral imposes a decision on you. In mediation, your result is binding because you voluntarily agree to that result to settle the dispute. So the bindingness is achieved, but more by way of voluntary than an imposition. The third is enforceability. We all know how great New York Convention is. 173 states have ratified, and I must say we love that convention. But for that, I don't think I would have been able to have such a very good practice in arbitration. And our students here in the IADS will have a special course just on New York Convention because it's fundamental fabric to international arbitration. But what about mediation? The first thing people immediately think about is the Singapore Convention for the enforcement of mediated settlement agreements. That is true. But I'd like you to think one step before that. Because the whole concept of voluntariness of mediation, you actually very rarely would need to quote-unquote enforce a mediated settlement agreement because the parties would be willing to comply because this is what they've agreed to, what they wanted to move forward. So I'm not saying it is not useful, but it is important to have a fabric of enforcement or what I would call summary or compulsory enforcement, but nonetheless it is not as important like in the context of arbitration or litigation where a result is imposed on you by the third party neutral. So I'd like to compare the advantages like that. Now then, looking again on why mediation as a choice when you look at arbitration or litigation, and I'd like to look at a number of actual factual situations with regard to these types of processes that are ongoing. Arbitration and litigation. Like it or not, we are here in a civil law jurisdiction, but like it or not, they tend to be adversarial. Being adversarial, like it or not, they tend to be confrontational. And therefore, like it or not, they tend to cause some damage to the relationship that are at hand. Mediation, on the other hand, is entirely conciliatory in approach. They have to be very inclusive, understanding, and taking on board the views of the others in order to get a result. So therefore, the confrontation is not there. The second point about litigation arbitration is that the third party neutral will impose a winning or losing position on the parties. With mediation, we emphasize it is a win-win solution. Why win-win? Because if you don't like it, you won't have settled. And if you won't have settled, you still have the arbitration as your falling back mechanism. But if you are willing to, it will be a win-win solution because both sides would be happy. So that's why it is a win-win solution. And the third party neutral doesn't impose a decision. He facilitates the negotiation. In arbitration and litigation, there is always one side who is right, the other side who is wrong, like a little bit of a win-lose. But in the context of mediation, we don't look at who is right and who is wrong. We don't look at breaching of contract. We look at the common interests of keeping this relationship going, for example, or keeping this matter settled so that the next contract can be drawn up. So therefore, there is no right and wrong, but common interest. The fourth element is jurisdictional restriction. Now, it's good and bad. In arbitration, one of the first things we think about is, does the tribunal have jurisdiction? And if it doesn't, then whatever the award he gives, it will be set aside. Mediation has no such limitation. The only limitation is what the parties are agreed to put onto the negotiation settlement agreement. So therefore, you can agree, as it were, beyond what is the crux of the dispute, like, for example, what about the other contract that we are having? It's boiling up some differences. Why don't we settle the two together? Now, in arbitration, you can't do that. The tribunal will be exceeding its jurisdiction, set aside, or not enforced under New York Convention. So the jurisdiction restriction is good and bad in that sense. The other element is control. Now, arbitration, the way I would always tell people is that the arbitrator is the master of the proceedings. He is the master of the proceedings. So if you can't agree, he decides. In mediation, it's always the parties who agree on the process. So therefore, they are the true master of the proceedings. What about the result? We already said the result is imposed by the decision of the third party neutral in arbitration and litigation, of course based on law and evidence, without a doubt on that. But in mediation, the result is also controlled by the parties. So no matter in an arbitration how well you are advised, some of you, those of us who are in and out of contentious proceedings long enough, like myself, I would have seen something very unexpected coming out of a result, even though we've done all our analysis. But when it comes to mediation, that won't happen because everybody would have already planned and looked for that. So that is the three main why IOMed has to be set up. Institutional gap, complement existing international dispute resolution mechanisms, and the advantages of mediation. What now, having established? We're just 1 month old, and we are running around trying to spread the word of mediation, but I try to encapsulate, given the interest of time, in the interest of time, I encapsulate it in 3 areas. One, of course, is to provide mediation services for international disputes. Second is to do capacity building. And third is to provide and encourage the, enhance the development of a mediation ecosystem and thereby international rule of law. Mediation service, the first one. Three types of dispute can be administered by the IOMed. State-to-state disputes, investor-state disputes, and international commercial disputes. They can all bring their disputes to IOMed, including non-member states. Because I mentioned we have 38 states, but there are still other states who have not yet joined, and their disputes can still be administered by IOMed. 3 types of disputes. Then the next thing is, what about the mediators? We have 2 panels of mediators from 2 sources. 2 panels is 1 panel for state-to-state mediation. Those of you in the room, like Professor Zhang, public international law experts, would see the need of a special breed of mediator dealing with state-to-state disputes. Another type of panel we call general panel, and they deal with international investment and international commercial disputes. So those are the 2 panels. And I said 2 sources. What are the sources? The mediators are designated by contracting states. So each contracting state can designate mediators for state-to-state and mediators for the general panel. The governing council can also designate state-to-state and general panel mediators. The governing council I mentioned a moment ago is constituted by the rectifying the states that have rectified the convention. At the moment 8, and we are expecting a few more. The first governing council meeting was conducted by 8 states, but we're expecting more. So the governing council would be the party that is going to be the second source. Why the second source? And I have to here say that we learned from the exit experience, because you will all know that in exit they have an administrative councils list, and I myself was first designated there before I was designated by my country, China. So there is that list, because that list would include people who have not been designated by their country, but the relevant people think that it is worth having that particular person on board, irrespective of nationality. So we then have a true international pool of people that is available when the Secretary General have to make an appointment if the need arises. The other thing with mediation is our rules. The rules are now available on the internet. You can look at our web. It's iomed.int. And on that particular web, you see, again, two sets of rules, one for state-to-state, the other for investment and commercial, and you can see how they are run there. Effectively, party autonomy, party control is our main theme. The Secretariat only steps in to facilitate and push it forward, but it's party control. So that's our first row. The second road is capacity building, and that we are talking about. In capacity building, I point out in two aspects. It's still early days, but we have in our minds what we're planning to do, and I'm saying it here because I see a lot of potential partners that we could have to do this capacity building exercise. One is raising awareness generally. Second is raising awareness to the parties who are going to use mediation, because they need to know how to use it. And third is training mediators. So this type of capacity building exercise will have to be done, and we would look forward to participating and working with partners on that. So with the two, it comes to my third point. Our third mission is to enhance mediation ecosystem. We hope that through all these things that are being done, through the talks, through the encouragement and promotion of mediation, the whole world will start to think first about negotiation, mediation, before they roll up their sleeves and in the mediation, in the arbitration or litigation forum, because that is what I believe will truly enhance the peaceful settlement of disputes, and therefore also promote and reinforce the international rule of law. Thank you very much.
International Organization for Mediation. I wonder, I'm curious, what's coming about the first case, with state-to-state case we submitted to you. I'm very curious about that. I think that, well, you may be very, could be the first case. Anyway, yeah. Now we second stage. Professor Volker Roeben from Durham. Volker, now floor is yours. Thank you.
Thank you very much for the kind invitation and the opportunity to speak to you. And I want to congratulate this wonderful law school on its 30th anniversary, a massive achievement. Thank you again for having me here, and also for putting together this panel. I think this is there was a really inspirational talk by the Secretary General. And it comes to mind, we were speaking about what comes to mind as predecessors or as precedents under Article 33 of the UN Charter, and really not much, to be honest. I think the one that comes to mind is really the conciliation process procedure under the Law of the Sea Convention, which I think has been one case really being settled in this way. In Australia and Papua New Guinea. And it is a perfect illustration of what you just said, because in that in that conciliation, and they came up with an innovative solution really for administering a shared energy resource between those two states. And I think the conciliation led to this legal regime, the unification, you may say so, unitization agreement. And it couldn't have been achieved by a top-down decision, right or wrong. So I think that is a perfect illustration of the virtues of mediation or conciliation that you were pointing out. In fact, I may also say that now you mentioned this, I think it may solve a specific issue of energy disputes that I also speak about in a minute, particularly the new type of renewable energy disputes, which often have to do with regulatory regimes, complex regulatory regimes, and may arise and do arise at all stages of that regulatory process. And often states just don't know really how to solve these issues or what the impact of regulatory changes will be. And an earlier way of settling regarding disputes regarding these changes through mediation may indeed keep the relationship intact, and then in this way serve both parties. So it's very, very interesting. I will now follow up a little bit with some examples or some remarks really on the more classic dispute settlement through arbitration, and in particular the energy-related ones. And I think because I need to focus here, I think those are particularly interesting in many respects because they do highlight some general practical developments in this area of dispute settlement. It's probably not surprising that that is the case because of the sheer frequency and importance of energy-related disputes in practice. I think there are now around 175 cases, treaty-based cases relating to energy pending or being considered. Well, that's a large majority of those cases of arbitration, and the sheer volume of those, the financial volume of those cases is also staggering. In fact, the energy-related disputes normally have a much higher sum claimed and actually also awarded in terms of damages than all other disputes have. So it is of enormous critical importance what happens in this for investment investor dispute settlement, but also more generally for commercial disputes in this field. I will focus more on the public law, international public law side in the remaining time to draw out some interesting developments in the practice, in particular in treaty practice, which is not so much considered in law schools rather than the arbitral practice itself. Before I do this, I think it is important also, and that was mentioned by the previous speaker, it's important to set the scene a bit in regard to international law and the innovative ways of defining what that is actually. And you may have actually followed this very closely. What the International Court of Justice has done in a so-called advisory opinion, and following on an advisory opinion of the International Tribunal for the Law of the Sea, and also in regard to the Inter-American Court of Human Rights. But the advisory opinion and the process itself is actually very interesting because it does involve more or less all states of the world, so not just two parties or three parties or so, by intervention, the classic model of litigation before the International Court of Justice, but ultimately almost all states had a voice, including very small ones, and not just the traditional states being represented in these proceedings before the World Court. That is important for the legitimacy of the outcome. And I highly recommend that as a case study really in law schools about how these disputes or these interpretive questions relating to the big multilateral treaties that govern the world can also be settled in an innovative fashion. There's no time here for me to go into the depth of this advisory opinion, but I think one point is really worth mentioning. It sums it up. As a consequence of these proceedings, I think we can talk about 2 points. One is that the international law relating to climate protection has gained in normativity. It is much more binding, much clearer and much more binding than it was before. It is also actually backed up by state responsibilities. So violation of obligations under the climate change regime has real consequences. And the other point, I think that's probably not so, has not been to emphasize so much, is that the court has established a principle of, you may call that systematic or strategic integration of the entire legal regime applicable to climate change. And that is really important. Because that allows an organized approach to what the law requires states to do, and an approach that actually overcomes the classic fragmentation of international law. You have dispute settlement here, you have climate change there, law of the sea there, and so forth. So this is all now seen as a system with an internally guaranteed consistency and principles that govern this, but most importantly also with an objective which is ultimately defined by the climate change treaty and the Paris Agreement, and the objective to keep the global temperature rise to well below 2 degrees Celsius and possibly 1.5 degrees Celsius. So that is effectively the background to what I'm going to say now about the changes in treaty practice, or in regard to treaty practice for investor states, dispute settlement. As you know, that is based on treaty. That's why we call that treaty-based dispute settlement. And it is ultimately based both in certain multilateral treaties, but very few, and mostly in bilateral and regional treaties. And I think that's the key that I want to get to. The bilateral treaties are the bilateral investment treaties that many states now have and use. And that's particularly important, obviously, for China as it becomes a capital exporting country, and will make more use of this. And then there are also the regional treaties, the free trade agreements in particular, that often have an investment protection chapter attached to them. Then there is the genuinely multilateral treaty, the Energy Charter Treaty here in our case, which however has suffered some problems more recently. Now if you go through these treaties, then I think the one point I wanted to highlight in terms of the development by states, and ultimately international law is really the law of states. The consent of state is the ultimate source of international law. And what have they done to address the issue of climate change and more generally environmental concerns? That's an observation that I wanted to draw out here in light of what the International Court of Justice has said about the systematic integration of climate change objectives into all aspects of international law. Now, in the first generation, if you want, second generation of bilateral investment treaties, the concern really was that it didn't give enough room to states making certain adjustments in light of public policy objectives, more generally speaking. So a bit weight towards the investors' interest, and in particular was therefore not possible for states to take account of their new obligations in regard to climate protection. And that is something that was leveled as a criticism towards the whole system. And in fact, the states have to a certain extent reacted to this and have modified many of those treaties. And that's really the important point here. One is a recognition in many of these treaties now that states the state of that receives the investment, the state, in other words, has recognized regulatory powers, and that the exercise of those are not necessarily by themselves already a violation of the standard of protection, be it either indirect expropriation or the fair and equitable treatment clause or standard. And more importantly, probably, there is also a parallel development to the General Agreement on Tariffs and Trade, which in Article 20 has a very interesting clause that allows states to make certain exceptions on the basis of protected and legitimate public objectives. And that now effectively has made its way into the whole set of new treaties on investment protection. Effectively, you now have a balance where the investors' rights and interests are protected, under, most importantly, under fair and equitable treatment and indirect protection. But it is also clear that the whole state has certain regulatory powers, and the exercise of those is not by itself incompatible with those standards. And in the most recent set of modified treaties, you see actually a reference to the system 20 of it. There is a set of limited exceptions for, in this case, the whole state to exercise its sovereign powers under. And then there is a sub-clause that limits those, the exercise of those powers to be not arbitrary or discriminatory. And I think that's a really interesting way of both moving certain learnings from one area here, trade law, to investment law, but also to strike a good balance between, on the one hand, the legitimate interests of investors, and on the other hand, the obligations of states to meet with their climate change objectives in particular. And that is fundamentally playing out in many disputes relating to fossil fuel energy investments. We also see that's the first development. The second, what you do see is a whole set of new disputes relating to the promotion of renewable energy investments by the host state, which then have to be adjusted in light of changing circumstances. Tariffs have to be modified, subsidies have to be revoked, and all these things that the state may have to do in light of changing circumstances. And this is really something that is still quite difficult to absorb. There have been many cases relating to European states actually under the Energy Charter Treaty. The Charter Treaty therefore was actually abandoned by many European states. But I think that probably the better solution might be what we heard earlier, is actually for these disputes into mediation, where a more gradual approach can be taken and learnings can be had about changes in regulatory policy and whether they can be mitigated by a conversation between the investor and the host state. Because, and that's my final point here, it is very clear that in order to meet the world's ambitions to the climate, we need a lot of investment. That's the trillions of dollars, and without that investment, certainly that ambition cannot be met. So investment protection has its role in enabling that investment, but it should also be seen in the light of such changing circumstances and new procedures as they have been explained.
they are all very good examples in the development of international dispute settlement mechanism. I think that very much emphasize on the kind of judicial protection of the public interest of such things. I wonder if Teresa, your mediation that way, I imagine that way to settle the dispute on bilateral level. But I wonder if you may also work a step forward to deal with the cases involving, the rule of mediation to protect public interest. Is it possible to do? Because some of the multilateral environmental treaties actually contain such kind of mediation, such as UNSCC, I think, is one of the examples. So it could be one, yes. Yeah, maybe not only for the private interest, but maybe also. Okay, thank you very much. Now we have our third speaker, Professor Jason Chuah. Now, online.
Now, one of the things that I would ask, so perhaps during this kind of sanction work, of course, it is important that some dispute resolution mechanism should continue to be offered. Right, so if I could then invite the Secretary to move on to slide number 4, which refers to problems with sanctions. So essentially, I want to touch on 4 things today, but I want to keep it fairly generalized because I think at this time in the afternoon, nobody wants to look at a very detailed letter of the law. But essentially what I want to do is to point out that as far as sanctions are concerned, there are 4 challenges which make arbitration, wherever the arbitration takes place, somewhat challenging and problematic. The first, of course, is the scope of sanctions law is always a little bit unclear and quite ambiguous. And of course, the second one is there may be a number of different legal sources that would implicate or impact on sanctions. And then the third is what would the effect be of these sanctions? And finally, how should we respond? So perhaps we all are quite familiar with the sanctions laws from the European Union as well as from the USA. So the European Union law says that it will be prohibited to directly or indirectly engage in any transaction with a legal person, entity, or body established in Russia, etc., etc. So we see here a reference to a prescription, to a prohibition that impacts on anyone who directly or indirectly engages in any transaction. And of course, one question that has arisen is, does this transaction include arbitration work? Now, this therefore leads to a number of Western-based arbitrations and arbitral tribunals, envisaging that this might be a problem because if they undertake or if they welcome or if they entertain arbitrations involving Russian entities or bodies which have been sanctioned, they themselves might be running foul of the law. And of course, in the USA, we see a comparable one, whereby it says that transactions by US persons or persons in the USA are prohibited if they involve transferring, paying, or dealing in the property of an entity or an individual who is sanctioned. Now, this, of course, raises some concerns for US persons, including arbitrators as well as practitioners of law, as to whether they might themselves be caught in this law if they were to entertain an arbitration involving a sanctioned person that is caught by this piece of executive order. Now, of course, we know that it is possible for licenses to be granted, etc. But you can see that, generally speaking, we are dealing with an environment which is perhaps a little bit conservative, an environment where people are quite risk averse. So if they may not be prepared to take the risk because, well, you know, what is it in it for me? And if you were the arbitrator and you were to go ahead with this, then you know you might yourself run foul of the law, as I said. So this is the premise for a good number of arbitration practitioners in this region to imagine that, well, if arbitrations involving sanctioned Russian companies and entities will not take place in the West, then could we perhaps entertain these arbitrations here, for example, in Singapore, in Hong Kong, or in Malaysia, or Indonesia, or in Thailand, or China? And so that is the question that I want to pose to us today. And it is really a business-related one, and of course, within a law background. And the business context is really this: is the arbitration business from the West involving these sanctioned companies possibly moving to the East? And so that's our starting point. So as I said, this has exercised a good number of a mindset in this region, and it is in a sense, there is no real right or wrong. We are beginning to see anecdotal evidence of some of these arbitrations occurring here in this region. As I've shown you in that slide earlier on, we have seen a multi-million-dollar arbitration take place in Singapore, and we see the arbitrations being commenced in Indonesia and in Hong Kong. Right, next slide, please. Now, one of the challenges is really this, that there are also a number of conflicting sources of law. And so far the focus is on Russia. But even with Russia, you find that Russia has passed its own law called the Law Number 171 FZ. Now, this law actually now provides for exclusive jurisdiction of the Russian state commercial courts in disputes involving Russians, sanctioned individuals and entities, as well as foreign entities which are controlled by them. So basically what this tells us is that under Russian law, it becomes imperative that despite the presence of an arbitration clause referring arbitration somewhere else, now all disputes must be brought before the Russian state commercial court. Now this, of course, is intended to, as you can see, counter the effect of the EU as well as the US sanctions laws. Now there is an interesting case recently involving Rosneft, and one of the parties had wanted to bring this action or commence arbitration in Singapore under the SIAC rules. But the Arbitrage Court of Moscow gave or granted an anti-arbitration injunction based on this law number 171-MZ. So you can see that it is quite difficult for arbitrators to know what to do, even if you are not in the West, but even if you are in the East, in Singapore, or in Malaysia, or in Hong Kong, or in Indonesia, or in China. Because this law says that you could be acting in contempt if you proceeded with the arbitration here in this region on the basis of an arbitration clause, because that arbitration clause has now been rendered null and void under this Russian law. So this leaves us in a little bit of a dilemma. Now, on top of that, we also know that during the last Trump administration, there were sanctions taken by the United States against Iran. But the European Union, on the other hand, decided to block the US sanctions laws by introducing its own blocking regulation. Now that meant that if you were an establishment based in the European Union, on the one hand, you think you may have to comply with the US law, but by complying with the US sanctions law, you would be acting in breach of EU law, and vice versa. So you can see that because there are a number of conflicting laws out there, this leaves arbitration practitioners in a little bit of a difficult position. Next slide, please. So this then takes us to some of the real practical considerations. And of course, question one is, can arbitration costs be paid? So obviously, if let's say the arbitration had gone ahead and this was in breach of US sanctions law, or in breach of EU sanctions law, or in breach of the Russian law, can arbitration costs ultimately be paid? So this becomes a real challenge for a good number of practitioners who may not have thought about this before. And of course, this is important. I mean, we don't do arbitration work for nothing. Now, of course, under the European Union, it is possible now to seek an exemption. In fact, there is a clear exemption being given to arbitration work, but the scope of it itself might be a little bit problematic. Now, as far as US sanctions laws are concerned, it is also possible to seek a license, but obviously there are no guarantees that your application for a license to be excused from complying with US sanctions law because it's an arbitration will necessarily be awarded. Next slide, please. Okay, so let's then, as I say, try to look at some of the nitty-gritty of what goes on once an arbitration is solved. Now, other than thinking about the costs, let's now think about the real situation of a sanctioned party who now appears before you and you being the arbitrator, and she or he tells you that I am now on the sanctions list. Could we have permission from you as the arbitrator to suspend proceedings until my situation becomes clear again? Now, obviously, on the one hand, if you were to give permission, then this is permission for indefinite suspension. And that, of course, means that to some extent, what you are doing is you're frustrating the nature of and the function of the arbitration clause. But if you didn't give permission, then you have been warned, haven't you? So I think that's also a bit of a question mark. What about lawyers? Now, in this case, which is a British Virgin Island case called JSC VT Bank and Sergei Taruta, one of the lawyers acting for the sanctioned company suddenly appeared before the tribunal and said, you know, I've had a conscience epiphany. So I've decided not to carry on representing this individual. So as an arbitrator, what would you do? Now, of course, it is possible for lawyers to step down and so on and so forth, but usually on good reasons. So would that constitute a good reason for the lawyer to decide that I will not act anymore? What about arbitrators themselves who have been perhaps nominated and they decided that I'm not going to act in this arbitration because it involves a sanctioned party? Now, then, of course, the money question comes back to us. Now, you know that arbitrators don't do this kind of work. Next slide, please. You know that arbitrators don't work without professional indemnity. Now, increasingly, insurers are asking for this or are laying down this kind of condition, this kind of requirement. They're saying that we will not provide any cover if the payment of such claim or benefit would expose the insurer to any sanction, prohibition, or restriction. And you can see that these clauses are really very much mirroring the ones we find in banking facilities. And so what do you do if you don't get professional indemnity? So at the moment, that question also needs to be investigated. Now, where I am, which is in Malaysia, insurers have not really thought about this, and they're still relying on the standard clauses to offer professional indemnity. So is that a risk that the insurance business will need to be perhaps cognizant of and then make provisions for? Next slide, please. Now, the PI policy that I have seen now ask the arbitrator or potential arbitrator, the potential mediator, the potential conciliator, and potential expert witnesses, they ask them this question in your application for a PI policy. They ask you specifically, do your business activities covered under this insurance involve any of the countries subject to sanction, prohibition, or restriction under UN resolutions or the trade or economic sanctions laws or regulations of the EU, UK, and USA? If yes, please provide details. Now, how would you answer this question? And if you were to, could you go back to the slide before? How would you answer this question? If you say yes, what kind of details would you provide? And at one level, you don't actually have the details at hand when you are applying for this policy at the time, because the business had not yet arisen, has not yet come onto your into your in-tray. But if you were to disclose this, is there a likelihood that you may not get covered? If you did not disclose this, then would you be liable for non-disclosure or misrepresentation when soliciting the PI policy? Now, again, this has to be thought about. So when I talk to lawyers here in this region who are looking at this new emerging phenomenon and thinking that, yes, well, we might be able to latch on to some of these businesses from Russia, I think it's a question we have got to ask very carefully. Now, of course, in the end of the day, it's more of a commercial question rather than a law question. As a commercial question, we have to decide whether the commercial risks are worth taking. So I'm going to wrap up now because I realize that my time is almost up. So very briefly, what I have said to us today is really this, that in Southeast Asia, and I can also imagine that in some parts of Asia, there is this belief, perception, that as sanctions laws begin to bite in the West, that Russian sanctioned companies and their business and commercial disputes might perhaps migrate east. However, whilst we see some evidence of that happening, we also see some real challenges. From a law point of view, there are three material challenges. The first is that, number one, we sometimes don't know whether sanctions laws would cover arbitration business. And what aspect of that arbitration business, for example? Problem number two in law is the fact that the scope, there are competing legislations as well as laws impacting on exactly that scenario. As pointed out just now, we have got the Russian blocking law. We have got EU blocking regulations. So it is not a very clear-cut, unambiguous situation for arbitration practitioners. And the third is that there are issues relating to arbitration procedures. So as I said, if a sanctioned party were to ask for indefinite permission for an indefinite suspension, for example, what about cost orders and things like that? So that needs to be taken into account. So those are, to me, three of the main legal challenges. The commercial challenges and professional challenges are, number one, will you be paid? Number two, will you be able to apply for a license or an exemption? There is an EU regulation that seems to allow you to do arbitration work despite the fact that the entities are sanctioned. This is a recent introduction. So it may be possible, but it may not be possible. It's not very clear. Are you going to take the risk, the commercial risk, of relying on this regulation, which has not yet been tested? The third commercial risk is, can you get insurance cover? Can you get insurance cover? So these are some of the commercial issues that you need to think about. And of course, by the end of the day, as I alluded to earlier, there are practitioners and arbitrators who decide that actually I don't want to hold on to this hot potato anymore, I'm going to step down. And if they do step down, obviously it may be to do with their reputation and other commercial considerations, but that then leaves a situation where somebody has got to step in and do the mopping up. So with that, I thank you for your very kind attention and forbearance, and I wish you all a very good evening and also a thoroughly edifying conference day tomorrow. Thank you very much.
I think we also have a lot of questions for you, so please stay with us to the end of this session. Now we have let's invite our last speaker, Professor Lisa Toohey, for her speech on the topic of mediation for the promise of mediation in international trade dispute settlement. Thank you.
Good evening, everyone. Thank you so much to our hosts for a very warm welcome and congratulations on this very significant milestone in your institution's history. I'm very honoured to be here. So we're returning to a topic that we began this session with, which is mediation. And I'd like to focus this evening on a particular subset of mediation, that is mediation in WTO disputes. So starting with two important interrelated observations or questions. One is that the dispute settlement system has long been considered to be the jewel in the crown of the WTO. However, it has been under increasing pressure commencing well before the current Trump administration. It's been under pressure, particularly from the United States, resulting in the appellate body no longer being functional. All right. So does it continue to earn its title of the jewel in the crown of the WTO? And at the same time, elsewhere in domestic systems and in international dispute settlement more generally, facilitated measures or methods such as mediation, conciliation and good offices have gained. And so why is it that despite the existence of these provisions in the dispute settlement understanding, that they're not really used? So the very clear ethos that underpins the WTO system is one of mutual reciprocity. So any breach of the WTO's rules is a challenge to the integrity of the entire system. In other words, in that context, access to justice in the WTO is essential, not just to deal with individual complaints by individual states, but also to maintain an international rules-based international order. So this principle is embodied very much in the design of the dispute settlement system, and it's reflected in its text. In other words, it's critically important that any solution in the WTO context has to be consistent with WTO principles. At the same time, we're in a world, as many of our speakers have already said today, of unprecedented change. The current political climate is not well suited to international cooperation for a range of reasons. And I think perhaps the nicest way of framing that is that state primacy has felt more important now than it has perhaps in the past decades. And so states tend to want procedural control over their disputes. They don't want to necessarily hand control over to an outside body to settle the dispute in the manner of an arbitration or a determination. However, at the same time, there are very compelling reasons why you might want to have the dispute resolved outside of your state. Okay, so you have domestic stakeholders, and it may not be politically acceptable for them for you to make a compromise. So there are important reasons why you still may prefer outside dispute resolution, even if you don't want the result, to be completely out of your hands. And this is where the value of mediation comes in. Our first speaker did an excellent job of outlining some of these reasons. In addition, we are in an environment where trade has been very much recognised by a range of states in a range of situations. And this also leads us to a situation where many of the biggest bugbears in the trade system are in what we call the grey zone. In other words, they're not always a clear violation of WTO rules, and when they are a clear violation, they're not always of a level that you might want to bring a full dispute, and yet there's absolutely no doubt that these irritants in the system are undermining the international rule of law. So, and then the final factor that I think really underscores the potential for mediation in this current environment is that we have, as I think Volker said before, very much a fragmented system, and it's a well-documented problem of climate issues being resolved here and trade issues being resolved here. And one of the real promises in mediation is its capacity to deal across these silos in a holistic kind of way. Another reason to consider mediation in the WTO context is due to the diversity of the WTO members, now numbering about 166 members. And between them having brought 642 disputes, when we drill down a little bit closer, we can actually see that really only 1/3 of the membership, roughly speaking, have actually brought disputes. In other words, the 2/3 of the membership, who are almost certainly experiencing trade disputes, have nonetheless not brought any kind of claim. And there are a large number of repeat players in the system. So 1/4 of the members who have brought a dispute have done so only once, but there's a very large number of cases that have been brought by the 4 or 5 largest users of the system. So in other words, there's a small number of countries taking up a lot of the dispute settlement time inside the WTO. So as Greg Schaffer has pointed out, the cost of WTO disputes is quite substantial. Usually it's about $1 million to resolve a WTO dispute, and $1 million has a very different meaning or significance in a small economy as against a large one. And so against this backdrop, we need to very carefully consider the access to justice problem that the current dispute settlement system is creating, and that we need something that's a little bit more accessible for states of all kinds if we want the WTO to have ongoing support. Okay, so mediation in the WTO, where do we stand currently? So the dispute settlement understanding very clearly sets a preference for mutually agreed solutions, which is this umbrella term that includes mediation, conciliation, and good offices. And it says that is clearly to be preferred. This is then amplified in Article 5, talking about the use of good offices, conciliation and mediation. But there is very little else to actually flesh out how these mechanisms should work in practice. And that's an interesting contrast, of course, to the determination procedures that exist under the DSU and which are very well developed. There is one communication from the WTO Director General dating back to 2001, but that doesn't really contain much by way of clear procedural guidelines. And I would say this is a major discouraging factor for states that might want to otherwise take up mediation. They simply don't know that much about how the process is going to work. At the same time, there are also significant cultural or behavioural challenges that perpetuate this problem of not using mediation, and therefore mediation not being used in the WTO context. The culture of adjudicated dispute settlement is very well established. Over 600 disputes have been adjudicated very successfully in the WTO. And party representatives, so at state level, have a very clear adjudication mindset. They know how to use the process, and there's not a lot of uncertainty about how dispute adjudication will proceed in the WTO. And you compares quite, the mediation communication compares quite unfavourably in that regard because it lacks structure and states lack experience in using it. So there is what you would call a path dependence. So there is less awareness, therefore there's a lack of awareness, and so on and on it goes. And something is needed to turn around that momentum and to reconsider the use of mediation in the WTO. But the other problem is a lack of experience and competence amongst the mediators themselves. So the WTO has not appointed a panel of mediators who are there ready to deal with disputes in the same way that they have for the standing panel of experts. It requires both technical competence in trade law, but it also requires a very distinct skill set that is not the same as the skill set that is required of panellists in the WTO. So much as Teresa's very specific capacity building is required, technical training to make sure that there is a panel of mediators who are ready to go if they're required in the WTO. And understandably, there have also been a lot of more competing urgent issues taking up the WTO's time than reform of this particular aspect of dispute settlement. Nonetheless, there are some strong precedents for considering a turn towards mediation in the WTO. So there have been a very small number of cases under the WTO and the GATT in which the mutually assured settlement procedures have been used. That has included the 2002 case between Thailand and the Philippines, which was dealing with canned tuna. So that was a 10-month mediation process that did lead to a resolution on the basis of an advisory opinion of the mediator. Those who are familiar with mediation parlance will be a little bit confused about the idea of a mediator issuing an advisory opinion, but we'll leave that for another day. But there are also examples of the mutually assured solutions in EC Bananas 3, which was not actually successful but did deploy good officers, and a couple of examples of unsuccessful conciliation under the GATT as well. However, if we look outside of the WTO specifically, we can see that, if we look outside the dispute settlement understanding, we can see that there is actually signs of a conciliatory culture within the WTO. And I'm thinking here of the quiet achievers of WTO dispute settlement, which is a specific trade concerns mechanism. So unless you're a real WTO boffin, you may never have heard of specific trade concerns. So this is a mechanism that exists to address disputes before they grow in size, and they're used very extensively in technical barriers to trade and also in sanitary and phytosanitary disputes. So the proven benefit of the STC system is that it's much cheaper, it's much faster, and it's a very effective way of resolving low-level concerns. They can assist the parties to reconcile multiple competing WTO agreements, and they can also help clarify technical regulations, and to use meeting time in the WTO insights on shared experiences of the parties and to give some benefit in those proceedings to other parties in the WTO. So they have shown themselves to be quite a good way of de-escalating tensions and preventing escalation to a larger dispute. So there's a great discussion in an academic piece by Holzer talking about the Turkey alcohol case and the way in which this successfully a broader dispute. The WTO also does use mediation in the sanitary and phytosanitary context, and again, unless you're a real SDS boffin, you may not have even heard of this because it's done quite quietly under the radar, so to speak. And so STS disputes can be referred out for mediation to the OIE, that's the French acronym, the World Organization for Animal Health, and it provides a non-binding, non-advisory mediation service that tries to resolve issues of regulation that relate to animal health and disease. So interestingly, it is voluntary, it's confidential, it's non-binding, so all the hallmarks of classical mediation. But the OIE mediators facilitate an approach that is based on both standards and science in order to resolve the dispute, and they've successfully done so in well over 50 cases to date. So this does give a very, very substantial precedent that mediation can and in fact does work in the trade context. So I think that's some very good cause there for optimism. And of course, in the broader international context, and I'm going to skip over these just because we're running a little bit out of time, there are a wealth of examples of mediation being used very successfully over an extended period of time. So these date back as far as 1899, 1907 with the Hague Convention. They have a very deep and rich history in public international law. The brand awareness of mediation generally is much higher than it was even 10 or 20 years ago, and that's also thanks to many jurisdictions integrating mediation into domestic civil procedure. And as an Australian, I'm very familiar with that. Mediation has been a fundamental characteristic of civil dispute resolution in Australia now for many decades, and it works very well. It doesn't just work to resolve an entire dispute, it's also very successful to resolve part of a dispute and make final adjudication much quicker and cheaper and easier. So for example, you can very successfully use a mediator to sit the parties down and to try to narrow the number of issues that are in dispute between them and narrow the adjudication just to the most salient and controversial issues. And for any of you who've read dispute settlement decisions of the WTO, you'll know what I'm talking about, where I think there's a real use case to be found there for that kind of approach. At the same time, in the context of regional and bilateral trade agreements, states are turning more frequently to mediation. So on this slide, there's a number of examples of recent free trade agreements that have explicitly included mediation elements in them, including an entire chapter in the EU-Singapore Free Trade Agreement, specific rules annexed to the CETA Free Trade Agreement, Canada and the EU, and another between the United Kingdom and Republic of Moldova, and I'm fairly sure there are others as well. That's great. I've made up a little bit of time. I think I'm standing between you and the end of the day, so I'm very happy to have further discussion on this after the session. But in terms of where to next and the priorities for institutionalising mediation more firmly within the WTO, I think the first is a public relations piece, the need for the WTO to communicate the service better to the user of the system, to actually communicate to states the benefits of mediation in the ways in which it can be used. Also supporting that with greater definitional clarity about what the three processes are, how they are different from one another and how they each work, and to create comprehensive rules of procedure to support them. Building a panel of experienced external mediators who are familiar both with the WTO's context and with the skills required of mediators specifically. Also, encouraging mediation to be binding before a dispute arises. So states in the WTO commit in advance to using the dispute settlement understanding if a dispute is brought. So in other words, it doesn't require consent at the time a dispute arises. And the same could be done for mediation and conciliation in good office. And then finally, there needs to be some clarification of the process by which you would notify and enter what we would call a consent order with the dispute settlement body in order to make mediation agreements properly enforceable in the WTO and to make sure that they fall back into the enforcement system that really is the hallmark of the WTO's dispute settlement system. So I absolutely take Teresa's point that usually mediated agreements are durable, but in the WTO context in particular, you have a lot of domestic side factors within a state that can make that Article 21.5 arbitration become necessary. And so having some sort of system that will allow for consent orders and make them enforceable in the same way as any other dispute settlement procedure becomes really quite important. Okay, so with that, I'd like to thank you all once again for having me here and for your attention. If this is a topic that's of interest to you, please do reach out, as it's a topic that I am very fond of. And so thank you very much, and I wish you all a very nice weekend. Thank you.
Current dilemma facing by the arbitrators and also the lawyers who are in this business. I think all the audience are just like me, feeling like, we know if we are going to the business of the arbitration, we know what to do. At least in some circumstances, when we face a dilemma of sanctions coming from, perhaps if we are representing a Russian company, that we're facing this dilemma of sanctions coming from both US and other states. So I think it's a very useful lecture. Okay, sorry, I didn't. Oh, sorry for the online audience. I didn't turn on my microphone.
So come to Professor Toohey. I read several of your articles, especially the one weaponized trade. I really like that one, the definition that you gave to that term. I think it's very important. And I also do research in WTO, so I'm very interested in your topic. And you've mentioned that if you are only in this circle, you would understand these terms. But actually, I've been doing this research in WTO, but I haven't heard of some of the terms. So raising awareness is so important to make mediation to happen, not only in IOMed, but also at the WTO. So I think that your lecture well echoes Professor Zhang's lecture. So let's raise awareness of mediation together to make it a path to potential perpetual peace of this world. Thank you.